Hello everybody and welcome to the latest of our SQE webinars. I'm Julie Brannan, Director of Education and Training at the SRA, and I'm going to be talking to you along with my colleague Len South, who is Academic Director at Kaplan. And today we're going to be talking about the final SQE design, so the overall shape of the SQE, and we're also going to be running through some detailed questions in the SQE2 Assessment Specification. So if we move on to the second slide, we're going to talk through what the overall design looks like, and on the draft assessment specification we want to highlight some particular points with you and draw to your attention that we will we've got a survey that accompanies the assessment specification draft that was published today, and we'd welcome your points, your views on through our survey. You may have some points or some questions or observations, and we'd like to hear from you about the assessment specification as a whole, but also some particular points that we'll pull out as we go through our presentation today. So if we move on to slide 3, this is now just to give an overview of where we are with the overall assessment design for the SQE. As I'm sure many of you are aware, our board at its recent board meeting took a decision about the final assessment questions, and this is therefore the shape of the SQE that emerges. As everybody is expecting, as has been the case for a long time, the SQE1 will assess functioning legal knowledge, candidates' ability to take their legal knowledge and apply it to contexts and scenarios and reach a decision about advice or next steps for a client. And SQE2 will be an assessment of practical legal skills. So SQE1 will consist of 2 separate assessments, each with 180 questions in them, and those will be separate standalone assessments which candidates can pass or fail separately. SQE2 will be 1 single assessment which candidates have to pass as a whole, and it will consist of, as we'll see in a moment when we look at the detailed design, 16 practical legal skills exercises which test legal skills and application of the law across the practice areas which are reserved activities and also business organisations. So that's the overall shape of the design: 2 separate assessments for SQE1 and 1 single assessment for SQE2. If we move on now to slide 4, this is a reminder of a bit more detail about SQE2. And at this point, Len, can I hand over to you and ask you to talk us through in a little bit more detail what the skills are and how they're sampled across the contexts?
So in terms of SQE2 skills, we've got the client interview and the attendance note legal analysis. We've got advocacy, and we're going to be looking at these in a little bit more detail in a moment. We've got case and matter analysis, legal research, legal writing and legal drafting, and pervasive across this, so that they're not bullet points here, pervasive through this is ethics and professional conduct. And so those are the SQE2 skills, and the contexts are criminal litigation, dispute resolution, property and practice, wills. If I say wills and intestacy, probate, administration and practice, if I can just say brackets, inverted commas, wills, we all know what I'm talking about. And then finally, business, organisations, rules and procedures, which again, we'll just call business from now on, which, as Julie, as you said, they're 4 reserved activities and business as well.
Yes, absolutely. And so the SQE is focused very much around those reserved activities, plus business, because it's such a wide area of practice for the profession. So those are the skills, and those are the contexts across which they'll be sampled. If we move on now to slide 5, this shows the proposed final design, which is in the draft assessment specification for the oral skills. Again, Len, could I ask you to talk through this?
Yeah. So obviously Kaplan and the SRA have been working together. We considered a number of alternatives, and the design that we've suggested takes into account giving priority to a number of factors. Obviously, the reserved areas that we've spoken about, the nature of the day one solicitor's role, and manageability and the cost effectiveness of SQE2. And so it also involves putting the tasks where they naturally belong. So advocacy is to do with rights of audience, it's to do with being based in a court. So it wouldn't feel right if we were assessing that in the context of business law. So just looking at the slide there, we've got oral skills, which are assessed over 2 half days. So the candidate would take 4 oral legal skills assessments. Day one, they would be doing it in the context of dispute resolution for advocacy and property practice for their interview and attendance note / legal analysis. Day 2, the advocacy is this time going to be criminal litigation, and the interviewing and attendance note is going to be in wills.
Yes, so you said there, Len, that they're 2 half days, and we have considered, haven't we, whether it's better to have this run as a timetable as 2 half days or 1 long full days. And I guess
both on balance, 2 half days.
That's right. There are always swings and roundabouts with this. We could have put it all in 1 long day, but it would have been a very long day, and we felt that some candidates would have felt tired and overfaced by all of that, so that it was fairest to assess it over 2 half days. And of course, particularly for those candidates who might need additional time, it's easier to accommodate those sorts of requests. So that's why we're proposing 2 half days for those assessments. And before we leave the oral skills, could you perhaps bring to life a little bit what the assessments look like? What happens in advocacy and what happens in interviewing?
Okay, so in terms of the interviewing assessment, this would be something that I'm sure candidates will be familiar with. They receive an email from a partner or from a secretary in the law firm, setting out who the client is and an indication as to what the client is coming to discuss. And there may be some documents that accompany the email, and the email is going to indicate specific legal issues which the candidates have to have particular regard to in the interview, and the subsequent attendance note case analysis. So they'll have 10 minutes to consider the email and any accompanying documents, and then they'll have 25 minutes to conduct the interview with the client. And they need to read the material carefully, because it's possible that the client will be someone who's vulnerable, they might have vulnerable circumstances, and the assessor who will play the role of the client is going to assess the candidate on skills. So the idea is that they win the client's trust and confidence, they obtain all the necessary information so they can fully understand what the client's concerns are. And then, as I mentioned, in terms of legal analysis and the application of the law, they're going to be writing up an attendance note with some next steps, some options, some strategies for negotiation. So although it is about skills, if you give client legal advice that is clearly wrong, that's not going to make them feel that they're going to trust you.
Yeah. So, but just to pull that point out, I think, as you said very clearly, the interview itself is being assessed on the client handling skills, and eliciting the right information, but that has to be recorded in the attendance note, and the legal advice then is picked up at that point. But it's a single assessment across those 2 elements, isn't it?
That's right, yes.
Yeah. And what about in advocacy?
So this is courtroom advocacy. So the candidates get a case study, and then based on that they'll conduct a piece of courtroom advocacy. So again, it's an email scenario. So the email asks them to conduct advocacy, tells them which court they're going to appear in. There may well be a file of documents that accompany that. And as you would expect in advocacy, you don't go into a courtroom and just present your case without a judge making any comment at all. So the candidates may be asked questions during the advocacy, and they'll have 45 minutes to prepare for this. and then they will have 15 minutes to make their submissions to the judge, and the judge will be present in the room, and the judge will be played by a solicitor, and will assess the candidate on both the skills and the application of the law. So the assessment objective here is that candidates can demonstrate that they can conduct a piece of advocacy before a judge.
Yes, thank you. So that's really helpful. So we've looked at the oral skills. Let's now move on to slide 6 and have a look at the written skills. So we've four stations in which are oral assessments, and then I think we've got 12 stations here, haven't we, which are the written exercises. And yes, so bringing up to a total of 16, as you say. So again, I was just wondering whether you could talk us through this and perhaps pull out some of the exercises and explain to viewers in a little bit more detail what they consist of.
So this is obviously a slide that's a little more complicated than the oral skills slide. So day 1, you've got 4 assessments there. 2 will be in the context of dispute resolution. 2 will be in the context of criminal litigation. Day 2, the context there are property practice and wills. And then finally on day 3, it's all business.
Yes, so before, I'm going to pick up on that, the balance between the different subjects in a moment, but before I do, again, do you want to pick up perhaps case and matter analysis and give us a talk through what happens there?
Yeah, so the oral skills, as we stated, were face-to-face with a client or face-to-face with a judge. Moving on to these are computer-based assessments, but it's not like SQE1 and MCTs. The candidate is given an electronic file of documents, and point to note is some of the documents may not be relevant, so they've got to use some skills here. And they're asked to produce a written report to a partner, giving a legal analysis of the case and providing client-focused advice. So this is about the client. It may include the need to consider options and strategies and negotiations. We'll look at negotiations in a few minutes' time. And this will be an assessment they will have 60 minutes to complete. And the objective is that they can demonstrate that they can produce a written report to a partner, giving a legal analysis of a case and client-focused advice.
Yes, I see. That's really helpful. And let's pick out another example. What happens in legal research?
Okay, so legal research, again, computer-based, and we're looking for a discursive piece of written English here. So they're investigating a problem for a client. Again, an email from a partner asking the candidate to do some research about an issue or a number of issues, so that the partner can report back to the client. So they're having to produce a written note explaining to the partner their legal reasoning and the key sources that they're relying on, as well as the advice the partner will give to the client. They're not needing to produce any kind of research trail. And just kind of health warning that while the subject matter of the research is going to be within the broad headings of the practice area in which the assessment is set, it may be outside the scope of the functioning legal knowledge, because that's why it requires research. And the candidates will have a suite of possible materials, which could include primary and secondary resources for the legal research exercise, and they'll need to work out what the relevant ones are of the material that they've been given. And again, this is 60 minutes to complete. And so the assessment objective is that they can demonstrate they're able to conduct legal research from a variety of resources provided and to produce a written report.
Yeah, thank you very much. And everybody, you'll see the detail of all of these exercises set out in the assessment specification, including legal drafting and legal writing, which we haven't got time to go into. So please do take a look there and let us know if you think it's set out clearly, if you've got any comments of additional information and so on you might find helpful. But it'd be great to hear from you on how we've described the nature of the exercises in the assessment specification. And then looking across the oral and written skills assessments, what I can see is that there are some differences in terms of what is assessed where. So I can see that we didn't have a business assessment in either interviewing or advocacy, but what we've got is more business assessments which are written. Again, do you want to just expand on that, Len, and perhaps share with everybody what the thinking is around that assessment design?
Yeah, so we've already discussed that business isn't reserved activity, and it just seemed to us that when we were looking at this that there's likely to be less emphasis on client interviewing for day one solicitors and more emphasis on written skills. So for business clients, talking about a transaction, so assessing a range of clients for a range of settings, private, business, commercial, that sort of thing, and assessing a full range of types of clients in those contexts in terms of getting instructions on a transaction. And again, we would welcome stakeholders' views on this decision and on the design of the SQE2 in general.
Yes, it says there on the slide it's a final design, but it's a final draft design, so it's still a draft assessment specification which is out there, so we are looking for your views on this. So that's the overall station allocation, so you get a bit more granularity of detail of how the skills are allocated around the practice areas. Can we move on now to slide 7? Len's mentioned negotiation a couple of times as he's been talking, and of course negotiation is a skill included in the statement of solicitor competence, but we don't have a skill like legal writing or legal drafting which says negotiation, so it's not itself a separate skill or a separate station in the assessment. Can you perhaps explain to viewers, Len, in a little bit more detail how negotiation is assessed through the SQE?
Yeah, so negotiation is clearly a very important skill to have, and so it may be assessed in case and matter analysis, legal writing, and in the interviewing and the attendance note. And so which of these three stations have negotiations in will vary between deliveries of the SQE2. But where negotiation is assessed, candidates will be asked to suggest options and strategies for negotiation within the context of those stations.
Yep. So how will candidates know whether they're going to be assessed in negotiation in a particular station?
Well, the clue is it'll be in case and matter analysis, legal writing, or interview attendance note, so they won't actually know in advance where it will be in any sitting of SQE2, but, and this is a top tip, they have to prepare to be assessed in negotiation for every sitting of SQE2.
Yes, so as Len says, that top tip, if the station is either case and matter analysis or writing or interviewing, there could be a negotiation point to pick up on. And then when we look at the detailed assessment criteria which are in the assessment specification, again, we don't see specifically anything which relates to negotiation. Can you pick up that point and explain what the thinking is around that, Len?
Yes, so it is reflected in the assessment criteria in terms of client-focused advice, which we've been focusing on, and application of the law.
I see. So in other words, when you're giving your advice, part of that advice, if it involves a negotiation point, would be about next steps and strategy and so on, and would depend on the underpinning legal principles involved in that scenario in terms of how to take the client's position forward. Thanks very much. So that's how we deal with negotiation. And what I want to do now is move on to a number of other points which we pick up in the assessment specification. So perhaps if we can move to slide 8. The first is the assessment of legal knowledge, and the first bullet point there makes clear that in terms of the assessment criteria there's a weighting 50-50 between skills and application of the law. And again, I want to hand over to you, Len, to ask why that split is considered to be appropriate.
Yeah, so So legal knowledge for SQE2 is a subset of the knowledge required for SQE1, and it's clearly set out in the assessment specification. And so what we're saying is, for this 50-50 skills and application of law, it's a question of demonstrating that candidates have reached the standard of competency of a day one solicitor. Candidates will need to demonstrate that they can apply fundamental legal principles in the skills-based situations covered by SQE2 in a way that addresses the client's needs and concerns. And so they're going to need sufficient knowledge to make them competent to practice on the basis that they can look up the detail later, and we'll look at legal materials in a minute. So candidates will not be expected to know or address detail that a day one solicitor would look up unless they've been provided with that detail, and that will be in the assessment.
So does that mean that candidates need to relearn all the legal knowledge from SQE1?
Well, if you compare the legal knowledge for SQE1 and the legal knowledge for SQE2, you can see that although there's an overlap, it's clearly not identical, so it's a subset. So they will need to know the fundamental principles which make them competent to practice in the areas covered by SQE2, but they won't be expected to know the detail that, as we say, a day one solicitor would look up unless that information is in their assessment. So to give you an example, if we take ethics, for example, so candidates would be expected to know the basic principles of ethical conduct relating to, let's say, conflict and confidentiality. But, for instance, if it was relevant in a property matter, they would be supplied with the standard conditions of sale. We wouldn't expect them to carry that level of detail, because that's the sort of thing that a day one solicitor would look up. And we're going to show how this will work in sample questions, which we're going to come on to. I think you're going to deal with that at the end, Julie.
Yes, indeed. Yes, yeah, that's quite right. Well, that's really helpful. And I suppose associated with legal knowledge is legal materials. You gave an example just there, Len, about people being provided with the standard conditions of sale. Can you talk us through the sort of legal materials that candidates might be provided with?
Yes, so as the slide says, so for all stations except legal research, candidates will be provided as part of their assessment materials with materials that a day one solicitor would look up. So they can take confidence from that, but they're not going to have to cram all kinds of weird and wonderful facts and figures and statistics into their mind. If it could be looked up, then they'll either get it or we won't be testing it. And so candidates will clearly need sufficient knowledge to make them competent to practice on the basis that they can look up the detail later. They won't be expected to know or address detail that a day one solicitor would look up, as I say, unless it's been provided in their assessment material. But legal materials will only be provided where it's considered that a day one solicitor would need to refer to those materials. And as we say, sample questions and indicative answers will be published on the SQE website in due course.
And moving on again, still on the topic of legal materials, to the next slide, I think this expands on what you've just said, Len, and actually is the wording which we've included in the draft assessment specification, so people can get a sense of what knowledge they need and what materials they will be provided with. I don't know if there's anything more to add to that, Len. Anything more you want to say on that?
It's country, isn't it? Yes.
Yeah, fine. Okay, so that there you are. Those are the points about how we assess legal knowledge and the legal materials that people can expect to be provided with. And again, do have a look at the detail in the assessment specification. If you've got any points or observations on that, then please come back to us. So let's move on then to the last topic really that we wanted to talk about today, which is about compensation. And compensation is where a candidate can compensate for poor performance in one area by outstanding performance in a different area. And some stakeholders do worry about this and think that actually people should be able to demonstrate that they're competent in all areas. In SQE2, because it's a single assessment, actually what we do is we take an overview and candidates pass or fail that assessment overall. Again, really, Len, a question for you. What did we looked at this, I know, in the pilot, and I'd be interested to hear from you what we found in the pilot and why do we consider this assessment design to be appropriate?
Yeah, so Julie, as you quite rightly say, the pilot investigated compensation between different elements of the assessment in detail. And whilst we found that compensation does occur, it's not frequent and it's not marked. So in general, good candidates tend to do well in all sections and weaker candidates do badly. So on that basis, we advised against separate pass marks for different elements of SQE2. And it's worth pointing out that pass marks for separate skills or elements of the assessment would be very problematic because the low number of assessment points they're based on means that they are inherently a less reliable basis for making pass-fail decisions than the mark for the exam as a whole. This would mean that we would otherwise not be sufficiently sure that those that pass deserve to pass and those that fail deserve to fail.
Yeah, so I think that's really an important point, that actually we did not observe a significant problem in relation to compensation in the pilot, but there would be it would be very problematic, as you say, Len, if we had separate pass marks for each of those individual subjects. Nevertheless, we will keep that under review, and I guess people particularly worry about ethics, and rightly so, because it's absolutely critically important that that candidates are able to behave professionally and ethically if they are admitted as solicitors. So how will we assess ethics, and how does the compensation issue apply to ethics?
Yeah, so the thing about ethics is good candidates, as we found out, tend to do well in all sections and weaker candidates tend to do badly. So the risk of candidates passing while performing badly in all the ethical questions is small. And in addition, the pass-fail judgments made on the basis of a limited number of questions about ethical issues would be, again, very problematic, as they wouldn't be sufficiently reliable for decision making in what is a high stakes professional exam. Candidates might get lucky, they might get unlucky. So the only alternative really would be a separate and lengthy exam on ethics. And the data at present doesn't suggest this is warranted, but you know, as with everything here, we will keep this under review.
Absolutely, yes. So there we are. That's the position on compensation and the overall shape of the assessment. I think we now just need to look at next steps. So we are launching a survey today together with the draft assessment specification, and that survey will close on the 28th of June. So you've got about 2 weeks to come back to us with your thoughts and observations on the assessment specification. Be very keen to hear from you, and we've outlined and set out above some of the points which you might want to think about when you're looking at the assessment specification and considering you know, the issues that are embedded in it. The final assessment specification then will be published in July, so we will have the opportunity to look at what you have said to us and pick up your thoughts, observations, comments, and so on, and take those on board before we publish the final specification. Len's also mentioned sample questions. We will also be publishing sample questions on the SQE2 with indicative answers, as Len said, so that people have those available to shape their understanding and expectation about how SQE2 works and what we're looking at. So those are the next steps in relation to SQE2 assessment. And then our final slide, which is the usual slide we always have up there, is just really about how to keep in touch more generally. There are the ways to contact us. We're very keen to hear from you generally, not just in relation to the survey that we've launched at the moment. So, but that is how to to make sure that we hear your views. So look, I think that is it. That's all we've got to say. Thank you very much indeed for listening to the assessment specification. If you've got any questions or queries, you know how to take those forward, and please do take the time to give us your thoughts and comments on the draft assessment specification. Thank you very much indeed.
Thank you.